Welcome to Righting Wrongs here at Hudgell Solicitors, the easy guide to the legal issues people may have to deal with in their lives. I'm Keith Phillips, and with me is our senior solicitor, Chris Moore, Joint Head of Clinical Negligence. Welcome, Chris.
Afternoon, Keith.
Well, Chris, you're here to explain how, on behalf of a family with a 20-year-old son with cerebral palsy, you secured a compensation settlement worth almost £24 million.
Yes. Well, the thing to know is that there are a number of causes of cerebral palsy, and not all of them are due to negligence. In this case, negligence was denied by the trust and by the NHS, and so we had to establish breach of duty of care negligence before the courts, and I'm very pleased to say that after a long battle we were able to establish negligence at the High Court back in October 2021.
Around 1 in 400 children in the UK are born with cerebral palsy each year.
Yes.
It's a brain injury which affects movement and muscle control. What are the causes of cerebral palsy that lead to claims for medical negligence?
Well, there can be a number of causes. I've acted successfully for claimants where the child was premature, and in that particular case I was able to argue that the pregnancy should have been prolonged for a greater period than it was. Other causes are maternal infection. We have some ongoing cases at the moment where we've been able to establish liability because of a failure to intervene earlier. But the most common cause is due to a lack of oxygen around the time of birth, either in the days leading up to birth or actually at the time of birth. And invariably what we are talking about here is a failure on the part of the hospital to intervene at an earlier stage and prevent injury.
Well, at what point, Chris, did this man's family come to think to themselves that his cerebral palsy could have been avoided and was due to negligence?
Yes, well, this case all centres around what happened back in October 2004 when the mother was 37 weeks pregnant. She attended an antenatal clinic and saw a doctor, obstetrician, and was given an ultrasound scan. And at the time, she expressed a concern that there was a lack of fetal movement. She'd not really felt as much movement from a baby in recent times. So she was examined, as I say, a scan was carried out, and the doctor completely reassured her that everything was fine. There was nothing to worry about at all. What should have happened is, and we've got expert evidence to establish this, is that the mum should have been placed on the CTG monitor and given strict instructions to return to the hospital if she continued to have any concerns at all about reduced fetal movement. Tragically, because mum had been completely reassured by the information she'd been given, the advice she'd been given by the doctor, she didn't return to the hospital until 4 days later. And this was when she became concerned that there was no response from the baby when she was actually having a hot bath, and she thought there may have been some response to the warm bath water. So she returned to the hospital at that point, and sadly, by this time, baby had been suffering from chronic partial hypoxia for a number of days, and was born with a severe brain injury. What I should say there is that the trust actually accepted that if the baby had been born up to 2 days earlier, then he would have been born free of any injury. But they denied that mum had ever raised concerns about the lack of fetal movement at the antenatal appointment.
Now, in this case, the child had cerebral palsy.
Yes.
The mother had a suspicion that negligence was behind it, but they waited 8 years before they sought legal advice. What happens when a family comes to you with those suspicions? How do you act upon it?
Well, The first thing you have to do is get a very good and clear proof of evidence from the family and also from her mother, who was actually present during the antenatal appointment. And from the outset, there was a clear conviction and consistency in the evidence that the family presented, which made me believe that if this case ever were to come to court, what they had to say would be very persuasive to the judge that heard the case. So there was a real conviction and consistency there, which made me believe in their case. But then you have to go through the process. You have to be extremely thorough. You have to have great attention to detail. You can't leave any stone unturned. You've got to present the best possible case. And the first thing you would do after you've got the statement would be to get the medical records to ensure there's consistency within those records with what the family are telling you. You then need to ensure you get the right experts involved for a case such as this. And then the final thing is to ensure you appoint the right barrister. I appointed a barrister that I thought would be ideal for this case, a barrister that I'd worked with successfully over a number of years in similar cases.
Well, let's take a step back. You say you need experts to back up your evidence. How does that work?
So we have a panel of medical experts, tried and trusted experts, and we look at who would be suitable for this case. We would write to them, approach them with the facts of the case, check there's no conflicts of interest or anything like that, no previous association with the potential defendant, and we go from there. I've done a lot of these cases over the years, so I have in my mind straight away the team of experts that I want to put together. Now the experts have to be independent; they're advising the court, but I know which experts will put together a good report, and more importantly, would have the conviction to stand by what they're saying if this case ever were to go to court, which of course it did in this instance.
Well, behind the scenes though, what are the experts doing for the family?
Well, they are simply providing reports to help prove the case. So they will comment on, as I alluded to, causation was established in this case. What we needed to do was to establish where the breach of duty, where the negligence rested, and what the failings were on the part of the hospital, and how if those failings had not taken place, we could have been looking at a much different outcome.
Chris, you're a solicitor with many years of experience successfully representing clients in multi-million-pound cases. Could you outline why this case took 12 years?
Yes, the simple but truthful answer is down to the intransigence of the NHS and their lawyers. I'm afraid. What we had here was a defendant that would not accept responsibility. They denied responsibility throughout. They resisted all reasonable settlement overtures on our part. When we eventually issued proceedings, because as I've said, we always felt that this was a good case, one that should be pursued. After we'd issued proceedings, we got directions from the court, and the court ordered us to consider ADR, alternative dispute resolution. And at one point, the defendants actually said, "Okay, well, we'll look at this. We'll have a mediation." We had a mediation. At the mediation, I was present with my client's counsel. My client's mother and father were there. The defendant's counsel was there, their KC was there, and the defendant's solicitor, as well as representatives from the trust. And all they did at that mediation was basically tell us that we didn't have a case, we will not be receiving any offers of settlement, and that we would be effectively wasting our time and wasting public funds if we took this case any further. And they said that to the family. So we had no option then but to pursue the case.
So throughout this whole time, the NHS Trust is denying that they were responsible for this child's cerebral palsy. How do you keep a family going through those times?
You've just got to stay positive. You've got to You've got to say that you've got faith in them. They've got to keep the faith. They've got to trust in the system. That we would persuade them that we would do our very best to deliver the best possible case, and that we would take it to the courts and let the courts decide if we had to. And I'm proud to say that after a long battle, we were able to take this to court and succeed and deliver justice for their son.
You did have to go to court in 2021. Why was it important that you went to court in the end?
It was necessary to prove the case. The NHS, their position was that the claimant's mother was mistaken. They say that at the antenatal appointment at 37 weeks, they said that mum wasn't seen by a doctor, she was seen by a sonographer, and it was the sonographer who performed the ultrasound, and that there was no mention by mum of concern around the lack of fetal movement. So they're saying right at the beginning she's got that wrong because the doctor doesn't perform the ultrasound. But mum had always been adamant that the lady who performed the ultrasound prior to her son being born was the same lady who she saw on the ward a few days after her son had been born. Sonographers do not tend to go around the wards, doctors do. So there was a ring of truth throughout there from what the mum was saying. Also, the mum's evidence was corroborated by her mum, who was actually at the appointment with her, and she recalls the mother asking and expressing concerns about the lack of fetal movement, and her being given the complete reassurance which she was given.
And going to trial, going before a judge, you were confident that your case would hold up?
I always felt that there was a conviction and consistency about the mother's evidence and the family's evidence, and that if we could get to trial, that what they had to say could well be very persuasive to a judge.
People listening may be wondering how an ordinary family, one that believes medical negligence is responsible for their son's disability, how do they get legal representation? Who pays for this 10 years of legal arguments?
Yes, well, first of all, I would say that any parents who have some concerns around the son's birth and or their daughter's birth, and as a result that there's been injury, that they should seek legal advice and seek advice from specialist medical negligence solicitors, and they'll be able to give good sound advice. In terms of funding the case, cerebral palsy claims one of the few claims the only claim in medical negligence cases whereby you can still get legal aid, so public funding there, and that's only available to specialist firms of solicitors who have a legal aid contract, which we have. But also, if legal aid for whatever reason isn't available, then we would look to fund a case like this if we thought it had sufficient merits pursuant to a no-win, no-fee agreement. So they don't need to worry about the expense, about what it could cost, because if we feel there is a case, we will be able to pursue it for them.
Now, £24 million is the possible total compensation package that will be awarded to this 20-year-old man throughout his life. It seems like a huge amount of money. I mean, how was that sum calculated, and why was it fair and reasonable?
It is a fair and reasonable sum, and it's a figure that we had to fight long and hard for. But it's the big number there is 24 million. But that's capitalised on the basis that the young man has his predicted life expectancy, and it's a combined lump sum and periodical payments order. So the initial lump sum is for just short of £8 million, that's £7.8 million, which will cover a number of aspects, including pain and suffering, loss of amenity, the various therapies which he needs throughout his lifetime. It also covers equipment, and it covers purpose-built accommodation. We will be building with the money, accommodation for this young man and his family. And within the accommodation, there will be purpose-built carers' quarters, there will be therapy rooms, and there will also be on-site hydrotherapy pool. But in addition to the 7.8 million, the rest of it is made up by annual periodical payments for his care and case management, both now and in the future. This is a young man that sadly requires 24-hour care. So what we have now is a care provision that will ensure that his needs are provided for throughout his lifetime, and those periodical payments will be paid for him every year that he remains alive. And so if he lives to his expected life expectancy, then the overall sum will be in the region of £24 million.
Overall, were you satisfied with the compensation package?
Yes, we got there. It's a package that is reasonable and fair. It's one that was approved by the High Court as being an appropriate sum. The only thing is that it, as I've alluded to earlier, I think this is something that should have been agreed sooner. As I say, it was 9 years before we had the trial on the issue of liability. After that, it took a further 3 years for the case to settle. There is a process to go through. We had over 20 experts involved in the case to help assist the court with how much the claim was worth to determine quantum. But we had what's called a joint settlement meeting back in April of this year, and I think we probably could have settled the case then. After that meeting, which lasted 9 hours, we were only a few £1 million apart, and I think we maybe could have settled within a short period of that time. But as it happened, the case was listed for a 10-day trial in October, and to determine quantum, and it wasn't until 2 days after the trial was actually due to start that we finally agreed on this settlement figure, which was approved by the court. And I think we could have spared the family quite a lot of trauma and concern about the prospect of having to go to court a second time if we'd dealt with the settlement, if not back in April, then a short time thereafter.
Well, with all your experience of working on cerebral palsy negligence cases, I mean, this is not an example of what always happens in cerebral palsy claims.
No. But what you tend to find is that because we're talking about a lot of money, that the claims tend to be hard fought, and in this case we could see that even after we'd established liability. But I think the family would say that whilst they wish it had been concluded sooner, it was very much worth the wait, because they now know that they have the peace of mind and a huge weight off their minds to know that their son will now be provided for both now and in the future.
Well, you have many years of experience, but were there lessons learnt in this case?
Well, I would hope that there'd been lessons learned from the NHS side. We were just presented with a case which we believed in, and we fought vigorously throughout, pursued the claim throughout, and presented the best possible case, and we eventually got the right result. From the NHS's point of view, they will have to look at what lessons that they wish to learn from it. I would just hope that in the future they may look at what we have to say and maybe come round to settling the case and agreeing a settlement sooner than they did.
Chris Moore, Joint Head of Clinical Negligence here at Hudgell Solicitors, thank you very much.
Thank you, Keith.
Thanks for listening to Righting Wrongs, and if you need further information regarding any medical negligence issue, head to our website, hudgellsolicitors.co.uk.